When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. There is some vague doctrine about unfairly splitting a case, which is based upon a textbook notion that, first of all, the Crown case goes in a neat package, followed by the case for the defense in a neat package, followed by the jury instruction and the verdict. Few trials are like that. For one thing, cross-examining by defense counsel during the Crown case helps to set up the defense. And conversely, cross-examining by Crown during defense case helps to bolster the prosecution. Sometimes the Crown may wish to reply to a point raised during the case for the defense by calling or recalling another witness. This is the problem which the panels are now going to consider.
A criminal case. The Crown case has been completed. The defense has called 3 alibi witnesses, but the accused himself has not testified. In reply, the Crown calls the detective.
His whereabouts at the time of the alleged crime?
Yes, I did.
And what did the accused say?
Well, he said he was in
Well,
the
Your
apartment
Honor, I
house.
object to this line of questioning. If the Crown wanted to put in some supposed statement of the accused, he had an opportunity to do so during the course of the Crown's case. He cannot put it in reply and thereby split his case.
Well, now, we have several problems arising out of this one. Do we agree at the outset will be unusual because we haven't agreed on anything so far this morning, have we? Do we agree at the outset that in cross-examination, the Crown may, first, put to the accused any utterance not made to a person in authority under Sections 10 and 11 of the Evidence Act? It's not made to a person in authority. The Crown happens to have a statement. Can the Crown in cross-examination put that to an accused? But if the person is in a position of authority, the Crown must first get a ruling or admission that it was voluntary, and for that purpose may conduct a voir dire even during the defense. Because I've noticed this coming up lately. At one time, the utterances of the accused or his statement or whatever they were put in as part of the Crown case in a voir dire, and then the Crown didn't introduce it in evidence. And in other words, they got a ruling as to his voluntariness. Now, very often, the Crown is faced with a situation that, well, perhaps they don't think the statement has any relevance or it's self-serving. And the falsehood in the middle of that statement isn't going to help one way or the other. But the accused gets into the box, and now he gives his evidence, and that one statement then becomes important because he showed he lied. And I find now getting applications more and more in the middle of the defense to conduct a voir dire as to the voluntariness of the statement as a condition precedent to going on and cross-examine. Now, do we agree that, gentlemen, that is a fair statement of the law?
Well, I'd agree with that. I'd like to just deal with this particular fact situation first.
Yes, you go ahead then. I was going to ask you a question about it.
First of all, it's an alibi defense that's being set up. One would think that in a normal situation, the defense would have notified the Crown of the fact that A, it's an alibi defense, and B, as to the nature of that defense. So the Crown knows exactly what's going to happen with respect to the defense. The next thing is, well, one would hope that defense counsel would do that. Now, next thing is that...
Say that again, please.
That the Crown is knowledgeable about the fact that the defense of alibi is going to be used.
Yes.
Okay, well, let's assume that that's so. So that the Crown isn't caught by surprise, but let's assume that that doesn't apply. And then the next situation is that the Crown then calls the police officer with respect to a previous statement made by the accused. In the first place, I would say that the Crown is not entitled to, and I think there's plenty of case authority, to split its case, if I may use that phrase, that is to trap the accused. And no one could possibly, although that could be suggested here, that's the first thing. The next thing is the Crown cannot call rebuttal evidence on collateral matters. And I think there's plenty of authority for that. But here the question is on the main issue of alibi.
No. With due respect, the Evidence Act gives anyone the right to cross-examine on a previous statement made by the witness that contradicts what he says. Am I right?
I'm agreeing that
Yes.
he can cross-examine, but I would say, first of all, the voluntariness of the statement would have to be proved. That's first
certainly
thing.
the Crown has the right to cross-examine so long as it's contradictory. Do you agree?
Yeah, I would think so.
All right. Now, the accused has made a statement that is contradictory. Call an evidence rather that's contradictory to show that he was somewhere else. He didn't get in the box himself. Now they want to show that the accused told them something that was false, I assume. Now, what the accused says is evidence of the truth of the fact asserted, isn't it?
Yes.
And if made to a person in authority, the only thing we have to do is show that it was voluntary.
We'd have to show it's voluntary, no question about that. Right.
Now, what's this splitting the case sort of thing? The Crown surely cannot, until the defense of alibi starts in, anticipate it and say we're going to put this in because we think they're going to raise a defense of alibi. Could they do that?
Well, I don't think the Crown is splitting its case.
Oh, I thought you said they were.
No, I don't think they are. I don't think they are splitting their case. I think they can bring in this evidence because it is the fact and issue. It is the main issue before the court, the question of alibi, and so that the Crown can call this witness now.
Then you say this is evidence in reply.
In reply. It's reply or rebuttal evidence.
So what is this so-called theory of splitting a case, and how do you distinguish it between valid reply evidence?
Well, I think the theory is, and I may have it wrong, but as I understand it, the idea is that where the Crown lays in wait and tries to trap the accused by evidence that it should adduce when it's putting in its case in chief. That's the main idea as I gather it from reading the cases.
In other words, if it's not really reply, then it's splitting the case.
That's right.
But if it's referable to, in any way to reply, then it should go in. Is that what you would say?
Well, as long reply evidence it may be admitted so long as it's not with respect to a collateral issue, and also so long as it's for the purpose of contradicting the evidence that's being adduced on behalf of the defense. If it's merely confirmatory, as in the Michaels case, where they try to call in reply evidence to show that the accused had made a statement in the back of the police car that in fact he had the marijuana and so on, and the Ontario Court of Appeal said, no, all you're trying to do now is to buffer the prima facie case you established, you, the Crown, have established. You can't do that.
In other words, it's not true reply.
That's not true reply.
Mr. Poole, what are your views on this?
Well, I'd like to, I think this is very important for the ladies and gentlemen here who are in the practice of criminal law, because it's going to come up. And it's going to come up more often as a result of the Supreme Court of Canada case 2 years ago, the Pichet case, Regina versus Pichet, in which Chief Justice Cartwright says there's no difference between an inculpatory statement or an exculpatory statement. The rules of admission apply to each equally. I think that's a change in the law. That's a 1971 case. In this particular set of circumstances, if I might repeat them, the man is charged with an offense. The Crown completes its case. The defense brings in 3 alibi witnesses who say that the accused, in effect, was not in Toronto, he was in London. The Crown, hearing that, has a statement from the accused in which he says, oh yes, I was in Toronto, but I wasn't on that street and I didn't do it. So he knows that the alibi witnesses are telling a story different from the statement of the accused. Excuse me. Because of that, the accused doesn't go on the witness stand. So at that stage, thank you, at that stage, you have the Crown, case completed, you have the alibi. And if the 3 alibi witnesses are either well enough paid or well enough believed, the Crown's going to lose its case. So what does he do? He has the statement, so in reply, he submits the statement. Can he do it? Well, the first question is, it must be established that it's a voluntary statement, and regardless of what it says after Pichet, can you have a voir dire under those circumstances? And the answer is yes, and the authority is Regina versus Drake, D-R-A-K-E, which is a decision of a single judge, Mr. Justice McPherson, in the Saskatchewan High Court. That's a 1970 case. Stands for the proposition you can have a voir dire anytime. Now, the second proposition I think you should be aware of is the Pelletier case, in which this fact situation occurred, and it's a decision of the Saskatchewan Court of Appeal, and the relevant judgment is that of Mr. Justice Brownridge, who comments on this very point but is a dissenting judge on other matters. That's also a 1973 case. And it says that you can have a voir dire anytime under the circumstance of this videotape. May I comment on one other aspect, Mr. Chairman? That's this. People say that the Crown can't split its case, and I hate to use this expression, but because it's dirty Poole. Terrible thing to say. Judges, even Mr. Justice McPherson in the Drake case, said this isn't the thing to do. But they never quote any authority. It's kind of like a game of girls' ground hockey. There are things you do and there's things you don't do. But I've always thought it was fair jousting for the Crown to put in a prima facie case and stop there. Then the onus swings to the defense, and if you can knock it off, then the Crown's entitled to bring in reply evidence. But where he's trapped, he can only bring in reply evidence which is resultant from the cross-examination. He can't bring in new matters, so he may trap himself. But there is no reason that I know of, despite the arbiter in all these cases, why the Crown can't hold a statement, have a voir dire any time, and spring it on you. I don't think defense counsel is surprised, because it was his client. That's one of the questions he's going to say. What did you tell the cops? He'll say, I didn't write anything down. What did you tell him in the back seat of the car when you're going from Windsor to London? He said, I'd swear on my unborn children. What else did you say? There they have it all. It doesn't need to be in writing. It just goes to wait. Now, I think that there is some authority that might suggest you can't do this. I think this is perfectly proper. There was a case in 1954 in the Ontario Court of Appeal, Rex versus Michael. Chief Justice Pickup said you couldn't bring it in a reply evidence to buttress up an otherwise weak case. I don't think that's the law today. I think you can distinguish the Michael case on other grounds. But I think the law today is set out in Pelletier. A lot of wisdom, you know, doesn't always exist in Toronto. There's a good Saskatchewan case. Teach the fellas from Toronto something if they read it, you know. A lot of wisdom out there.
Can I just respond to
Yes. You're responding on behalf of Windsor?
Yeah. I just want to say that there is another very recent decision that would be well worth looking at, Supreme Court of Canada decision, Perras, P-E-R-R-A-S, in which the question of the sanity of the accused came into question. And the Crown, the defense put in a psychiatrist without notifying the Crown that they were going to call this psychiatrist. And he said that the man was suffering from organic amnesia. Well, the Crown, in reply, wanted to call their own psychiatrist who had seen the accused at the time he was arrested and so on, and not with respect to any statements made by the accused to the psychiatrist, but rather only to prove his mental condition. And the Supreme Court of Canada, although there was a division of opinion, but the majority did hold that evidence could go in on that particular point to show the mental condition of this particular accused. Now, I still think that the authorities, if you look at the Ament case, the Michaels case, some of the cases mentioned by Professor Ratushny in his afternoon lecture, indicate this. That if you look at the Raphael case, you can call reply evidence so long as it's with respect to the main issue involved and so long as it's contradictory. But the moment you call reply evidence on a collateral issue, as for example in Raphael, where this fellow was charged with fraud and with respect to, he was a travel agent, I believe, in Toronto, and he promised these people landed immigrant status, and he denied making income tax returns. The Crown then called reply evidence, which was almost in the nature of hearsay, but to show that, in fact, he hadn't made any income tax returns. And the Ontario Court of Appeal, Mr. Justice Arnott, said, no, you can't do that, because that's not the main issue before the court. The issue is the question of fraud. This is on a collateral issue, namely credibility. It's got nothing to do with it. You can't call reply evidence on that particular point.
Thank you. At this time, I should turn over the meeting to the chairman of the day, Professor Mewett, but may I say on behalf of the panel that we thank you for inviting us here, and we trust that you've enjoyed this morning half as much as we have.
All right. Perhaps I can look to Professor Morton first. There are a number of issues here, but to begin with, is the Crown here splitting its case? Can this sort of thing be done at all?
I think the expression split a case is very hard to pin down. I've never discovered any very precise rule about it. It seems to me to reflect a number of possible situations. Perhaps the word evidence and rebuttal gives me a better picture than talking about splitting case. And the sort of case that I think of is, for example, everyone I'm sure is familiar with the rule that the prosecution can't set out to show the man as a sort of bad man likely to have committed the offense in the first instance. So suppose you have Thompson charged with indecent assault on little boys, and they know he has a record for this type of behavior and the chronic behavior pattern of this sort. Generally speaking generally, the prosecution cannot set out in its case in chief to establish that Thompson is the sort of man to commit this sort of offense for the purpose of showing that he likely committed it. Suppose, on the other hand, Thompson decides to avail himself of his right to go into the witness box and goes in and says specifically in his examination in chief, I am not the sort of man to indecently assault children. I am a pillar of the church, a choir master, a cub master. I devote all my life to good works. I am not the sort of man to do a thing of that sort. The rule appears to be that the prosecution can now offer evidence and rebuttal. Because Thompson has raised the issue at that stage, they were precluded from doing it up to that time. Now he has opened the way for them to do it, and it's perfectly proper for them to, I don't like the word split the case, but offer evidence and rebuttal. Now, different considerations, I think, apply to situations where the case is closed or the case is finished than to cases where an issue arises for the first time late in a case. Again, I don't want to sort of be a vociferous minority here. I do think Mr. Justice Weatherston in the preliminary discussions did perhaps incline to the view that this case had a lot to do, this particular example, had a lot to do with fair play. A rather simple notion rather than a technical rule.
It may be wrong, but I know there's a sort of a general theory that the accused should have a fair trial and he should be allowed to lie if he wants to lie. And really, that's what's happening here. What bothers me here is that I think that the only purpose of calling this reply evidence is to say that the alibi witnesses are not telling the truth. And aren't we then really calling witness in rebuttal on a collateral matter? Because the principal fact is, did this man commit the crime? The witnesses say he was in Thunder Bay at the time. And then the Crown is now wanting to call some evidence that the witnesses are lying. Not that the accused was in any particular place at the time, because it certainly wouldn't be admissible on that basis. So maybe it's just basic fair play, but certainly I think it's wrong that this evidence should be called. I think it's simply not admissible, and I'm not sure if you analyze it properly, you can simply say that you're trying to rebut evidence on a collateral matter, and that's not proper.
All right, well, let me just add a few more details then, perhaps. Let's suppose the charge is murder, and the statement that the Crown is attempting to use here is a statement in which the accused says, yes, I was in the apartment, but in effect I was only trying to defend myself, and goes on to give an exculpatory version of how the death took place. Now, when the Crown puts in its case in chief, there'd be no reason in the world why they would put in a totally exculpatory statement like that. However, as soon as the defense puts in a defensive alibi, then that part of the statement which deals with his location becomes extremely pertinent. How then, Mr. Justice Weatherston, is where he was merely a collateral issue? Isn't that one of the material facts and issue as to whether or not he was there?
Well, anyway, doesn't this Pichet case cover the matter? It seems to me that...
Well, okay, there's another point as to whether or not this is voluntary and all that, but let's just deal with the main issue as to whether or not this kind of evidence comes within the ambit of things that the Crown can do in reply.
Well, it seems to me that the only purpose of the reply is to say that these alibi witnesses are liars, and that's all. And you can't assert positive facts.
Well, not only are they liars, but the accused was in the apartment.
Well, if you want to prove that as a positive fact, it should have been called in chief and not in reply.
I see. So you wouldn't let it in?
No.
I see. All right, well, if we can assume for the moment, well, I think maybe I should just say then that just so we don't send everybody away feeling that this is settled, I don't agree. I would let it in. I feel that it's a material issue. The defense raised the question of the location of the accused, and it's open to the Crown then to meet that allegation of his being in Thunder Bay by now proving that he was somewhere else, whether that comes out of the mouths of other witnesses or whether through the utilization of a statement. Now, if you accept the fact that I'm right for the purposes of argument, Professor Morton, what then should be done? Can the statement be admitted in just this way? And what I'm driving at is the Crown here...
I'm just trying to nerve myself to assume, with the greatest respect, that this would be permitted.
That may be tough, but you might be in that situation someday where you'll have to assume that I'm right for the purpose of going on with it. So if you could just learn to live with that.
Well, I think Pichet would apply quite clearly, and there'd have to be a voir dire. I think the onus would again be, as usual, be on the Crown to establish that the statement was made without any improper inducement or compulsion.
Yeah.
I think that is particularly, Pichet is particularly significant here because it's just possible that the Crown Attorney might say, I'm not offering this to show that he was in the apartment at all. I'm offering it to show that he, the person who would know best where he was at the particular time, said that he was someplace else than the place where these alibi witnesses were put in. I don't care whether he was in the apartment or not. If he'd been in Paris, France, it would have suited my purpose just as well. He said he was in Paris, France. They said he was in Thunder Bay. That would be the argument I would say. And so the Crown Attorney would presumably take a position, I'm not offering this as truth, as evidence of the truth at all. And in which case, I would have to respond then that Pichet requires you to establish the voluntariness of the statement, whether you're relying on its truth or not. So there'd have to be a voir dire, in my view, and the judge would have to rule on voluntariness.
All right.